Welcome back to the deep dive. The world of real estate, especially here in California, can often feel like a dense forest. It really can.
Oh, absolutely.
It's full of winding paths, hidden thickets of jargon, and legal complexities that can make even seasoned professionals scratch their heads sometimes.
Definitely.
But what if there was a shortcut? A way to navigate those complexities, uncover surprising facts, and truly get well informed without feeling, overwhelmed by an information tsunami.
That would be ideal.
That's precisely what we're here for today. We're embarking on a deeply personalized journey, a custom-tailored deep dive into the foundational concepts of California real estate principles. Think of this as your bespoke study guide, designed to pull out the most important nuggets of knowledge, connect the dots between seemingly disparate ideas, and really zero in on those concepts that often trip people up. Our goal is for you to walk away feeling confident, clear, and truly understand what's important.
Indeed. And we've got a comprehensive set of materials to work with. It covers pretty much everything, from the fundamental nuances of property ownership right through to the intricate layers of agency relationships and real estate finance. Our mission isn't just to define terms, it's to distill these concepts. We want to make sure you grasp not just the what, but also the why and how they matter in the tangible real world of California real estate transactions. We'll be focusing on key areas that are frequently challenging, transforming those complex ideas into clear, actionable insights for you.
Perfect. So whether you're diligently prepping for an exam, looking to brush up on a critical field, or simply insanely curious about how real estate truly works beneath the surface, settle in. We're about to explore the essential building blocks, delve into the fascinating details, and unpack the practical applications that make real estate such a vital, dynamic part of our lives. This is going to be a fascinating conversation.
Laying the groundwork, unpacking property ownership and interest.
All right, let's start at the very beginning, right, with the foundational question. What does it truly mean to own or simply have an interest in real property here in California? It's clearly more intricate than just holding a piece of paper that says deed, isn't it?
It absolutely is. That's a great starting point. When we talk about interest in real property, we fundamentally differentiate between what are called possessory interests and non-possessory interests. And this distinction is critical because it defines the scope of rights someone has over a piece of land.
Okay, possessory versus non-possessory. Got it.
Right. A possessory interest, often referred to as an estate, gives a person the present right to actually occupy or possess a property. Now, this can range from outright ownership to the right of temporary use.
So like owning versus renting, basically.
Exactly. That's a good way to think about it initially. A possessory interest can be an ownership interest, which comes with the full bundle of rights. You often hear that term. Imagine a bundle of sticks, where each stick represents a different right. The right to possess, use, enjoy, exclude others, and dispose of the property. This whole set of rights is what a homeowner automatically receives with the title.
Okay, that bundle of sticks makes sense.
On the other hand, a possessory interest can also be the right a renter has. They possess the property for the duration of their lease. They don't own it, but they have a legal right to occupy it. Now, within possessory interests, we have several key types. Freehold estates are forms of ownership with an indeterminate length, meaning they don't have a fixed end date.
Indeterminate. So potentially forever.
Potentially forever, yes. The quintessential example here, and what most people truly think of as owning a home, is a fee simple absolute estate. This represents the maximum ownership one can have of real property. It's of indefinite duration, freely transferable, and freely inheritable. You can sell it, gift it, pass it down through generations without restriction.
That's the big one.
That's the big one. The key insight here is that fee simple absolute is the ultimate bedrock of property rights in America. It means you own the dirt, the air above it, within reason, and everything permanently attached to it. No inherent end date or external conditions unless you choose to impose them. Understanding this is crucial because it defines your legal power over the asset. It gives you the broadest possible control for development, inheritance, or sale.
So that's the ultimate ownership. But even within that, there can be conditions, right? You mentioned imposing them. And what about situations where someone has the right to occupy but not truly own, like that renting example?
Precisely. Even within freehold estates, nuances exist. For instance, an estate might be a fee simple subject to conditions subsequent. This grants perpetual ownership, but with a condition attached. If that specific condition is violated, say, the property must always be used as a public park. The original grantor might have the right to reclaim the property. So it adds a layer of complexity.
Okay, so absolute isn't always completely absolute if there's condition.
Exactly. Then you have leasehold estates, also known as non-freehold or less than freehold estates. These are interests in the occupation of a property established through a lease, and they explicitly do not include ownership rights. They're possessory, yes, but for a defined period.
Right, the lease term.
Correct. There are 4 primary types here. An estate for years, sometimes called tenancy for years, is for a definite fixed period, like a 1-year apartment lease. Specific start and end date, no notice needed to terminate. A periodic tenancy runs for a specified period, say month to month, and automatically renews unless either party gives proper notice. An estate at will, or tenancy at will, is for an indefinite duration. It can be terminated by either party at any time with proper notice. Less common these days.
Okay.
And finally, an estate at sufferance. This occurs when a tenant stays on the property after their legal right to possess is expired. They're essentially suffering the landlord to remain. We call this tenant a holdover tenant.
So they're there without permission, technically.
Technically, yes. Their initial entry was legal, but their continued presence isn't. We also encounter life estates. Now, these are types of freehold estates, but they're limited to the duration of a measuring life.
A measuring life. What does that mean?
It means the estate lasts only as long as a particular person is alive. This can be the life of the person holding the estate, who we call the life tenant. Or it could be a different designated third party, which is called pour autre vie. That's French for the life of another.
Huh. So the property right depends on someone else staying alive.
Exactly. For example, someone might grant a life estate to their elderly parent saying, "Mom, you can live here for the rest of your life." Upon the parent's death, the property doesn't go to the parent's heirs. Instead, it either reverts back to the original grantor, that's a reversionary interest, or it passes to another designated third party, which is called a remainder interest. It's a powerful tool for estate planning.
That distinction between duration and the bundle of rights is definitely key. So once we understand what kind of interest we're talking about, the next natural question is, how many people can actually hold that interest? Is it always just one person, or can it be shared among multiple parties? That seems like another area where things could get complicated.
Excellent question. And yes, it can absolutely be shared. Property can certainly be held in several different forms, beyond just individual ownership. The simplest form is ownership in severalty, sometimes called tenancy in severalty. It sounds plural, but it means sole ownership.
Severalty means single. Okay, that's a bit counterintuitive.
It is a bit. It means severed from any co-owners. So one person or one legally recognized entity like a corporation or an LLC owns the entire property exclusively. For example, if a developer, through their LLC, owns a parcel of land, that LLC is the owner in severalty. No co-owners sharing title directly.
Straightforward enough. What about sharing?
Then you have co-ownership, also known as concurrent ownership. This is when ownership is shared with another person or persons. And this is where things get really interesting and where those exam questions often pop up. A key concept here is undivided interest. This means each co-owner has the right to possession of the whole property, not just a specific divided portion.
So you can't draw a line down the middle of the house.
Exactly right. It's not like you own the kitchen and your co-owner owns the living room. You both have access to and rights over the entire property. Another vital concept, especially for co-ownership, is the right of survivorship. This is a statutory principle. When one co-owner dies, their ownership interest automatically transfers directly to the surviving co-owner.
Automatically, so it doesn't go through their will.
Correct. It bypasses the probate process, which can be a significant benefit for planning. Without this right, the interest would typically go to their heirs, which is known as the right of inheritance.
Okay, survivorship versus inheritance. Got it. So what are the main ways to co-own?
There are a few distinct types, each with different implications. Tenancy in common is the most common form of co-ownership for unmarried individuals. Tenants in common have an undivided interest, but crucially, they have the right of inheritance. Their share goes to their heirs upon their death, and they can own unequal shares of the property. Maybe one person put in 70% of the money, the other 30%. That's allowed in tenancy in common. This flexibility makes it popular for business partners or friends investing together.
Unequal shares and inheritance. Okay. What's the alternative?
Contrast that with joint tenancy. This involves 2 or more people. Joint tenants also have an undivided interest, but they usually have the right of survivorship, and they always hold equal shares. Always. Plus, they must have acquired the property together at the same time, with the same document, and with the same right to possess.
At the same time, same document. Sounds specific.
Very specific. It's often remembered by the 4 unities. Unity of possession, unity of interest, equal shares, unity of time, acquired simultaneously, and unity of title, acquired via the same document. If any of these unities are broken after the joint tenancy is formed, say one joint tenant sells their share, the joint tenancy can automatically convert into a tenancy in common for that share.
Wow. Okay, so maintaining those four unities is critical for joint tenancy.
Absolutely. The biggest draw, though, is usually that right of survivorship, which simplifies inheritance.
So if I'm trying to decide between tenancy in common and joint tenancy with a friend, maybe someone I'm buying an investment property with, what's the single most important factor I should consider? Why? It seems like a key decision point.
That's a great question, and it's definitely something that often trips people up, both conceptually and in practice. The single most important factor is your intent regarding what happens to the property when one of you passes away. It's all about succession.
Okay, death and succession.
Exactly. If you want your share to go to your heirs, maybe your children or someone named in your will, regardless of who survives, then tenancy in common is your choice because it has the right of inheritance. If, however, you want your share to automatically transfer to the surviving co-owner, completely bypassing probate court, then joint tenancy is the answer, assuming you meet the four unities. This is a critical discussion to have up front with your co-owner. You need to be crystal clear about your intentions to avoid future disputes or unintended consequences for your estate. It really dictates how the property passes on.
That makes perfect sense. You have to plan for the end game, essentially.
Precisely. Now, for married couples in California, the rules are different again. California operates under a community property system. This means property acquired during a marriage is considered owned equally by both spouses, a 50-50 split, regardless of whose name is technically on the title or who earned the money to buy it.
Acquired during the marriage is key there.
Very key. Property owned before marriage or received during marriage as a gift or inheritance specifically to one spouse is typically considered separate property. But community property generally requires both signatures to sell, lease for more than a year, or encumber, like taking out a mortgage. This concept also extends to registered domestic partners in California, ensuring equal rights.
What about property bought elsewhere and then you move to California?
Ah, good question. That brings up quasi-community property. This refers to property acquired outside of California that would have been community property if the acquiring spouse had been domiciled in California at the time of acquisition. So if a couple moves to California from, say, New York, a separate property state, assets acquired during the marriage in New York might be treated like community property for purposes of division upon divorce or death in California. It prevents someone from losing rights just because they moved.
Interesting. California law reaching back, in a way.
In a way, yes, to ensure fairness upon dissolution of the marriage or partnership here. And beyond direct individual or co-ownership, property can also be held in trust. This is where a legal entity, the trust, holds property for a person, known as the trustor, the creator of the trust, until it's ready to pass to an heir or beneficiary.
So the trust owns it, not the person.
Legally, yes. A trustee, an individual or entity, is entrusted to manage these assets according to the trustor's specific instructions outlined in the trust document. Trusts are incredibly powerful tools for managing and distributing assets. A major advantage is often avoiding the lengthy, public, and sometimes costly probate process.
Avoiding probate is a big deal for many people.
It really is. There are different types of trusts. Living trusts, created while the trustor is alive. These can be revocable, meaning the trustor can change or even cancel it, or irrevocable, meaning it generally cannot be changed once established. Then there are testamentary trusts, which only come into being when the trustor dies, usually created through instructions in their will. And land trusts, which are specifically designed to hold land, often for long periods, perhaps for privacy, avoiding liens, transferring land discreetly, or planning for future development without immediate public disclosure of ownership. That flexibility and privacy are often key drivers for using trusts.
The burdens navigating encumbrances and liens.
Okay, this is fascinating. We've covered ownership. Here's where it gets really interesting, I think. Because even if you have clear ownership, like that fee simple absolute, there can be outside forces or claims on a property, right? Imagine you own a property, but someone else has a right to use part of it. Or maybe there's a financial claim hanging over it. These are what we call encumbrances. What exactly falls under that umbrella and why are they so critical to understand?
Right. An encumbrance is essentially a non-possessory interest in a property that burdens the title. Now, that word burdens is key. It means it affects the owner's full use or transferability of the property, but critically, it does not prevent the transfer of title itself.
So it doesn't stop a sale, but it complicates it. or reduces value.
It can, yes. Think of it like a permanent scratch or a dent on your car. It's still your car, you can still drive it and sell it, but its appearance or function is affected, and it might be harder to sell at full value, or a buyer might demand it be fixed first. These encumbrances generally fall into categories like liens, which are financial claims against property for debt, easements, a right to use another's land for a specific limited purpose, and deed restrictions, provisions limiting how the land can be used, often found in homeowners association, HOA rules, or
The
CC&Rs.
CC&Rs, covenants, conditions, and restrictions.
Mhm.
Those can definitely limit what you do.
They certainly can. Now, a cloud on the title is a bit different. It's a dispute or uncertainty that affects the clarity of ownership, preventing the title from being freely transferable until resolved. It's essentially any unresolved claim or dispute that casts doubt on who truly owns the property or whether it's free of certain burdens. Could be an old, unreleased lien or forgotten heir claiming an interest, maybe a boundary dispute with a neighbor.
So it does potentially stop a sale, or at least delays it significantly?
It usually does, yes. Until that cloud is legally cleared, often through a quiet title lawsuit, the property effectively sits in legal limbo. No buyer or lender will typically proceed until it's resolved. It's also important to distinguish these true encumbrances from things that affect property owners but aren't encumbrances in the same legal sense. For example, a license.
Like a driver's license.
No, in property terms, a license is temporary, revocable permission to use property. Imagine your neighbor says, "Sure, you can cross my yard to get to the park." That's a license. They can withdraw that permission at any time. It's not a permanent interest like an easement.
Gotcha. Temporary permission.
Right. And an encroachment is a physical intrusion, like a fence built slightly over the property line, or a shed corner that's on the neighbor's land. This is a physical problem, a trespass, not a right to use.
So you need to move the fence, not grant a right.
Ideally, yes, or come to some agreement. That key distinction between a license and an easement is revocability. The license can be withdrawn, the easement generally cannot unless terminated through specific legal means. And getting back to deed restrictions for a moment, they are legally connected to the deed and typically run with the land, meaning they bind not just the current owner, but future owners too, until legally dissolved.
So those HOA rules stick around.
They usually do, yes. They are a form of encumbrance.
Okay, easements always seem to cause a lot of questions and frankly sometimes confusion or disputes. Let's dive deeper into those. What are the different types and how do they even come into existence? Or, just as importantly, how do they get terminated?
Easements are definitely a nuanced area, and yes, they often lead to neighborly disputes, so understanding them is key. Fundamentally, they grant a specific right to use a property without conferring ownership. We classify them in a few ways. An affirmative easement gives someone the right to use a property for a specific purpose, like using a shared driveway or a utility company running lines across your backyard. Most easements are affirmative.
Okay, the right to do something.
Exactly. A negative easement, on the other hand, prevents a property owner from doing something that would otherwise be perfectly legal. For instance, preventing you from building a structure that blocks a neighbor's protected sunlight, or views sometimes called light and air easements, more common in dense or hillside areas.
The right to prevent something, yeah.
Right. Another absolutely vital distinction, and one that causes a lot of confusion, is between an easement appurtenant and an easement in gross. An easement appurtenant runs with the land. It's tied to a specific parcel of land and benefits that land. It transfers automatically with ownership.
Runs with the land, like it's attached.
Exactly. So if parcel A has an easement to cross parcel B for access to a public road, that right isn't just for the current owner of parcel A. It transfers to any new owner of parcel A automatically. The property that benefits from the easement is called the dominant tenement it dominates. The property burdened by it is the servient tenement it serves.
Dominant benefits, servient is burdened. Got it.
An easement in gross, however, is tied to a specific person or entity, not the land itself. A classic example is a utility company's right to run power lines across multiple properties. That right belongs to the utility company, not to an adjacent piece of land. It doesn't benefit another specific parcel.
So the utility company owns the easement, not the neighboring property.
Precisely. Now, a powerful and often misunderstood type is easement by condemnation. This is where private property is taken for public use via eminent domain. But instead of taking full ownership, the government just takes an easement. Maybe they need to run a sewer line under your property. They condemn an easement for that purpose, pay you fair compensation, and create the easement through government action, even if you object.
That ties back to that idea of condemnation we mentioned earlier.
It does. Same principle, government taking, but here just for use, not full ownership. Easements are typically created in specific ways, most commonly by grant in a deed where the property owner explicitly grants the right in writing, or by an agreement between parties. Sometimes they arise by operation of law known as an easement by implication, like an easement by necessity when a parcel of land is sold and becomes landlocked, requiring access across the seller's remaining land.
So how do these easements disappear? Is it as simple as just stopping using them for a long time? That seems like a common belief.
That's a great question, and it's a common misconception that simply not using an easement makes it vanish. It's generally more complex than that. There's a handy acronym to remember the ways easements can be terminated. ARPMEC. Okay, what does that stand for? Think of it as a really practical method to end claims. It stands for abandonment. But this requires more than just non-use. The easement holder must show clear intent to give it up permanently. Actions often speak louder than words here. Release. The easement holder formally gives up the right, usually requires a signed legal document, like a quitclaim deed releasing the easement right. Prescription. This is the inverse of creating a prescriptive easement. If the owner of the servient estate, the burdened property, openly prevents the use of the easement for the statutory period, 5 years in California, the easement can be terminated. Merger. This happens when the dominant and servient estates are reunited under one single owner. If you own both the benefiting and burdened land, the need for the easement ceases and it's extinguished.
Makes sense. You don't need an easement across your own land.
Exactly. Expiration of purpose. If the specific reason the easement was created no longer exists, it terminates. For example, an easement granted for access to a specific road, and that road is permanently closed or rerouted. Or court action. A judge can order an easement terminated if it's deemed no longer necessary, or perhaps if the burden on the servient estate has become unreasonable and wasn't anticipated.
ARPMEC. Abandonment, release, prescription, merger, expiration, court action. Okay, that's helpful.
Now, it's absolutely crucial to distinguish adverse possession from a prescriptive easement. They get mixed up all the time, and it's a common point of misunderstanding, especially on exams.
Right, they both sound kind of similar, using someone else's property.
They do share some elements. Both involve use that is hostile, without permission, actual, open, notorious, and continuous for a specific period, 5 years in California. But the key difference is fundamental. A prescriptive easement grants use of the property. Adverse possession grants ownership of the property.
Use versus ownership, that's a huge difference.
Huge. So if someone uses a path across your land openly and continuously for 5 years without your permission, they might gain a prescriptive easement to continue using that path. They get the right to walk there. But to claim ownership of that strip of land through adverse possession in California, they would also need to meet another critical requirement. They must have paid the property taxes on that specific piece of land for those same 5 consecutive years.
Yeah. Paying the taxes, that sounds like a big hurdle.
It is. This additional requirement for property taxes makes successfully claiming adverse possession significantly harder than getting a prescriptive easement. It's a critical differentiator in California law and protects landowners from easily losing title.
That clarity on easements, and especially the difference with adverse possession, is so helpful. Now, what about liens? They sound like a more direct financial burden. How do they work? And what happens when there's more than one lien on a property? Especially in a worst-case scenario like a foreclosure. That priority seems critical.
Liens are indeed direct financial claims against a property, usually acting as security for a debt or obligation. They are a non-possessory interest, but they have teeth that can potentially lead to the forced sale of the property to satisfy the debt. We classify them in various ways. First, voluntary liens versus involuntary liens. Voluntary liens are created intentionally with the owner's agreement. The most common example, a mortgage or deed of trust taken out to purchase a home. The homeowner willingly places this lien on their property as collateral for the loan.
Okay, you agree to it, like a mortgage.
Exactly. In contrast, involuntary liens are obtained through legal action or operation of law without the owner's consent. A classic example is a mechanic's lien. Imagine a homeowner, Gloria, hires contractor Jeff to build that dream pool. The pool looks stunning, but a payment dispute erupts. Jeff can file a mechanic's lien against Gloria's property.
So Jeff has a claim directly on her house.
Yes. This lien acts as his legal protection, allowing him to place a direct claim on Gloria's property itself, securing his payment for the work and materials he provided until the debt is settled. Another common involuntary lien is a judgment lien, resulting from a lawsuit where a court orders property to be sold or used to satisfy a debt owed by the property owner. Tax liens are also involuntary.
So the courts or law can impose these liens.
Correct. Liens are also categorized by what property they attach to, general liens or specific liens. A general lien attaches to all of the debtor's property, both real estate and personal property. Think of federal income tax liens or judgment liens. They follow the person and attach to almost everything they own.
Everything. Wow. Okay.
Whereas a specific lien applies only to a certain identifiable property. Examples are a mortgage lien only applies to the house being bought, that mechanics lien only applies to the property where the work was done, or a special assessment lien.
Special assessment, like for new sidewalks.
Exactly. If the city installs new sidewalks or a sewer system in a particular neighborhood and charges the adjacent homeowners, that creates a specific lien on just those properties benefiting from the improvement.
Okay, that makes sense. Now, the priority question. If a property has multiple liens, maybe a mortgage, a mechanic's land, and unpaid property taxes, who gets paid first if the property is sold, say, in foreclosure?
Lien priority is absolutely critical, especially in foreclosure or short sale situations. The general rule, often summarized as first in time is first in line, dictates that liens are prioritized in the order they were recorded in the public records. The earlier the recording date, the higher the priority.
So the oldest recorded lien gets paid first. Seems logical.
It does, but there's a major exception that often catches people off guard and is a frequent source of confusion and incorrect assumptions. Ad valorem taxes, which are general real estate property taxes based on value, and special assessments always take priority over any other kind of lien in public records, regardless of when those other liens were recorded.
Always. Even before a first mortgage recorded years earlier.
Always. Property taxes and special assessments are considered to be in first position. They get paid first from the sale proceeds, period. Then, other liens are paid based on their recording date.
Wow. Okay, that's a huge exception. So taxes trump everything.
Taxes and special assessments, yes. So in your example, mortgage, mechanics lien, property tax lien, the unpaid property taxes would be paid first. Then, assuming the mortgage was recorded before the mechanics lien, the mortgage lender would be paid next, and finally, the mechanics lien holder would get whatever is left, if anything. Understanding this hierarchy is vital for lenders, investors, and property owners. A lien that comes first in priority is called a senior lien or superior lien. Any lien that has another lien superseding it is a junior lien or inferior lien. This priority dictates the risk involved, especially for junior lien holders.
The players deconstructing agency and brokerage.
Okay, so we've talked about the property itself and the claims against it. Now, what about the people who actually make these complex transactions happen? We're talking about agents, brokers, clients, customers. It feels like the relationships here can get really interesting and sometimes maybe really confusing, especially regarding who owes what loyalty to whom. How do these relationships work, and what are the fundamental rules of engagement in California?
That's a critical area, absolutely, for anyone involved in real estate, whether you're a professional licensee or just a buyer or seller navigating the process. An agency relationship is formed when one party, the principal or client, authorizes another party, the agent or broker, to act on their behalf and, importantly, in their best interests in dealings with third parties. And a key point in California, these agreements for real estate services, like listing agreements or buyer representation agreements, must be in writing to be legally enforceable. This creates a clear record and avoids he said, she said situation.
Must be in writing. Got it. That seems crucial for clarity.
It is. Now, a really key distinction here, and a point of frequent misunderstanding, is the difference between a client and a customer. An agent works for a client. The client is your principal, the one you have the agency agreement with. You owe this client the highest level of loyalty and specific legal duties. However, an agent works with a customer. A customer is typically the other party in the transaction, or someone you're interacting with but don't have a formal agency agreement with.
So if I'm a seller's agent, the seller is my client, and the buyer walking through the open house is initially a customer.
Exactly. To that customer, the buyer, you owe duties of honesty, fair dealing, reasonable skill and care, and proper accounting if you handle any funds. But you don't owe them the same level of fiduciary loyalty you owe your seller client. You can't, for instance, advise the customer buyer on how low they should offer.
That would violate loyalty to the seller.
Precisely. For example, if agent Anita has discussed real estate with buyer Bernie, but Bernie hasn't formally signed a buyer representation agreement, Bernie is Anita's customer, not her client. An agency relationship hasn't been formally created in writing, so those higher fiduciary duties aren't owed yet. This distinction is vital for understanding legal responsibilities and avoiding conflicts.
Okay, client versus customer. That's clear. What about those duties owed to a client? You mentioned fiduciary duties.
Yes, the foundation of the agent-client relationship lies in fiduciary duties. This represents the highest level of trust and confidence recognized by law. It means the agent must always put the client's interests first, even above their own self-interest. There's a widely used acronym to remember these core duties: OLDCAR.
OLDCAR. Okay, what does that stand for?
It stands for obedience. The agent must obey all lawful and ethical instructions from the client. Loyalty. This is paramount. The agent must act solely in the client's best interests, avoiding any conflicts of interest or self-dealing. You can't serve two masters whose interests conflict. Disclosure. The agent must reveal all material facts pertinent to the transaction to the client. A material fact is anything that, if known, could cause a buyer or seller to take a different course of action or change their mind about the price or terms. This includes facts about the property's condition, zoning issues, or even information about the other party if it's relevant and not confidential.
Full disclosure is key.
Absolutely. Confidentiality. The agent must keep a client's private information confidential. This includes things like their reasons for selling, their financial situation, or their bottom line price. This duty is particularly significant because it lasts forever, even after the transaction closes and the agency relationship ends.
Forever. Wow.
Yes, protecting client confidences is a permanent obligation. Accounting. The agent must handle client monies, like deposit checks, carefully and responsibly. This means no commingling, mixing client funds with the agent's or broker's personal or business funds, and maintaining proper, accurate records. This duty, like confidentiality, also lasts forever. Financial trust is sacrosanct. And finally, reasonable skill and care. The agent must employ their expertise, knowledge, and diligence on the client's behalf. Clients rely on their agent's professional competence, so agents are expected to perform at a certain standard. This means knowing the market, understanding contracts, and guiding the client competently through the process.
OLDCAR. Obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill, and care. That's a comprehensive set of responsibilities indeed. Beyond those duties, how do we classify agents based on the scope of their authority? Does one agent handle everything, or are there limits?
Good question. Agency relationships are also classified by their scope of authority, which defines how much power an agent has to act on behalf of their principal. Special agency is the most common type in residential real estate, particularly the relationship between a broker and their client, the seller or buyer. In a special agency, the agent has narrowly defined authority to achieve a single specific objective, like selling one particular house or finding one particular type of property. Crucially, special agents generally do not have binding authority. This means they can't sign contracts or make binding decisions on the client's behalf. They find the buyer, negotiate offers, but the client signs the final purchase agreement.
So the agent facilitates, but the client decides and signs.
Exactly. For example, associate licensee Chelsea can sign a listing agreement for her broker because she's acting as a general agent of the broker in that specific context. But she cannot sign a purchase agreement offer for her seller client, Sue, because she's only a special agent to Sue and lacks that binding authority. Her role is to facilitate, not commit the client legally to the deal.
Okay, special agency is limited scope. What's broader?
General agency. This relationship is broader, often ongoing, and authorizes the agent to perform a range of activities within a specific business or area of concern for the principal. A very common example is the relationship between a real estate broker and an associate licensee, a salesperson or broker associate working under them. The associate licensee acts as a general agent for their broker for the purpose of conducting real estate activities. A general agent does typically have binding authority within their specified scope. They can make certain day-to-day decisions or sign certain documents on behalf of the principal within that defined area. Another example could be a property manager authorized to handle all aspects of managing several rental properties for an owner.
So ongoing relationship, broader scope, maybe some binding power. Got it. Is there anything even broader?
Yes. Finally, there's universal agency. This grants the broadest possible scope of authority, giving the agent the power to act and make decisions on behalf of the principal in all business matters. It's quite rare in real estate. It usually requires a formal legal document like a power of attorney, which makes the agent an attorney, in fact, with virtually unlimited binding authority to act as the principal. This is typically reserved for very specific circumstances, like managing all personal and business affairs for someone who is incapacitated or living abroad long term.
Paternity, in fact. Universal power. Okay, that sounds major. Definitely rare, I imagine.
Very rare in typical transactions. So understanding these scopes special, general, universal, helps clarify what an agent can and cannot do for their principal.
That's a lot to keep straight, and it really sounds like understanding these distinctions is paramount for everyone involved. Speaking of clarity, California has some very specific and frankly strict rules about agent types and relationships, especially when things get complicated. Dual agency comes to mind. What's the deal there, and why is it such a sensitive topic? It seems to pop up a lot.
It does, and it's a concept that is frequently tested and often misunderstood, leading to potential legal trouble if handled improperly. It raises the important question: how do agents navigate representing different parties in the same transaction? Single agency is the clearest and most straightforward model. Here, one agent represents only one party in a transaction. They're either the seller's agent, the buyer's agent, the landlord's agent, or the tenant's agent. That's it. The agent's loyalty is undivided, ensuring they can advocate fully for their client's best interest without any conflict.
One agent, one client in the deal. Simple.
Simple and clean. Dual agency, however, is where the complexity and potential conflicts arise. Dual agency occurs when both a buyer and the seller are represented by the same brokerage in a single transaction. Now, this can happen in two main ways. Either the same individual broker or associate licensee works directly with both the buyer and the seller, sometimes called direct dual agency, or, more commonly, two different associate licensees from the same brokerage. Each work with one party. One agent lists the property, another agent from the same firm brings the buyer. Even though they are different people because they work for the same broker, it's still considered dual agency for the brokerage firm.
Ah, so even with two different agents, if they're under the same broker roof, it's dual agency.
Correct. The brokerage firm is the dual agent. The critical issue here is a compromised service and limited loyalty. Think about it. The seller wants the highest price. The buyer wants the lowest price. The seller wants favorable terms. The buyer wants theirs. How can one agent, or one brokerage, truly advocate 100% for both sides simultaneously when their core interests conflict?
They can't really. Someone's interests might not be fully represented.
Exactly. The dual agent cannot provide full, unfettered disclosure or undivided loyalty to both parties. For example, if the seller confidentially tells the agent, "I'm desperate, I'd actually accept $50,000 less," and the buyer confidentially tells the same agent, "I love this place, I'd probably pay $20,000 more if I had to," the dual agent cannot ethically disclose this vital negotiating information to either party. Doing so would violate their duty of confidentiality to the other party.
So they're stuck in the middle, unable to give the best advice to either side.
Precisely. It creates a very difficult balancing act. This is why, if seller Jenny and buyer Kelsey are both represented by broker Whitney, but neither Jenny nor Kelsey is aware that Whitney represents the other, this is an instance of undisclosed dual agency. That's a severe violation of agency law, because the parties haven't consented to this compromised representation. If broker Kenja represents seller Franklin, and then another buyer represented by Kenja's brokerage wants to make an offer, Kenja and her broker must disclose this potential dual agency situation immediately and get written consent from both Franklin and the buyer before proceeding with the negotiation. Or the brokerage might choose to only represent one party and refer the other out.
Informed consent seems absolutely critical here.
It is non-negotiable. Because of this inherent conflict and the potential for a fundamental breach of trust, informed consent in writing from both parties is legally required before entering into or proceeding with dual agency in California. This is often done using specific disclosure forms, like the California Association of Realtors Form AD, Disclosure Regarding Real Estate Agency Relationship, which explains different types of agency, and Form AC, Confirmation of Real Estate Agency Relationships, which confirms the specific agency relationships chosen by the principals for that specific transaction. And even with consent, a dual agent can only disclose to one party that the other party might accept different price or terms with explicit written authorization from the party whose information would be disclosed. It's a very high bar.
So the takeaway is that dual agency, even when disclosed and consented to, inherently compromises the agent's ability to offer that full, undivided loyalty we talked about with OLDCAR.
That's the core issue, yes. Their primary fiduciary duty becomes a tightrope walk, trying to balance inherently conflicting interests. This is why undisclosed dual agency is considered such a cardinal sin in real estate. It completely shatters the trust that the agency relationship is built upon. The consequences are rightly severe to protect the public.
What are those consequences?
They can be significant. An agent or broker found guilty of practicing undisclosed dual agency can face disciplinary action from the licensing board, including suspension or revocation of their license. They can be forced to forfeit their entire commission from the transaction, meaning they get paid nothing. And they can face civil lawsuits from the injured party or parties seeking damages for the breach of fiduciary duty. It's taken very seriously.
As it should be. Okay, what about subagency? You hear that term sometimes.
Subagency is a concept that's less common today but still technically legal in California. It's essentially an agent of an agent. While you could argue an associate licensee working under their broker is technically a subagent of the broker acting for the client, the term subagency traditionally refers to a situation where an unaffiliated cooperating broker assists a listing broker in selling a property without representing the buyer. In this scenario, the cooperating broker actually owes fiduciary duties to the seller, even though they might be working day-to-day with the buyer.
Wait, so the broker showing the house to the buyer actually works for the seller. That sounds confusing for the buyer.
It is very confusing, and that's one reason it's rare now. A subagent owes the same fiduciary duties, OLDCAR, to the principal, the seller, as the primary listing agent does. But it's risky, primarily because of vicarious liability. The listing broker becomes legally responsible or liable for the actions, errors, or omissions of that unaffiliated cooperating subagent, even though they don't directly supervise them.
So the listing broker is on the hook for what some other broker does.
Yes. Because of that risk, many brokers now explicitly state in their MLS listings that they're not offering subagency, only cooperation with buyer's agents. This clarifies relationships and reduces liability. So if Broker Barb brings her buyer client to look at a property listed by Broker Troy, Barb is operating as a buyer's agent, representing her buyer, not as a subagent of Troy representing the seller. That's the much more common and preferred setup today.
That makes sense. Clearer lines of representation.
Exactly. Now, an interesting point about ending agency relationships relates to something called agency coupled with an interest.
Agency coupled with an interest. What's that?
This occurs when the agent has a direct financial or ownership interest in the property itself, beyond just earning a commission. For example, maybe the broker loaned the seller money for repairs secured by an interest in the property and has a listing. In these specific situations, the agent's interest is greater than in a typical agency agreement. Because of this, the principal, the client, does not have the usual right to unilaterally revoke the agency agreement whenever they want. The agent's interest protects the agency from being terminated prematurely by the principal. So the agent's financial stake gives them more security in the relationship. In essence, yes, it prevents the principal from pulling the rug out after the agent has invested more than just time. Also, agency can sometimes be created after the fact through ratification. Say Hank's listing agreement with Sally expired yesterday. Today, Hank brings Sally a great offer from a buyer he found. If Sally accepts the offer and agrees to pay Hank the commission, she's essentially ratified his actions, creating an agency relationship after the fact, even though the formal agreement had ended.
So actions can sometimes create the agency relationship, too.
They can, though written agreements are always the proper way. Finally, agency relationships don't last forever. They can terminate in two main ways: by operation of law or by acts of the parties. Termination by operation of law happens automatically due to certain events: the performance of the contract, the sale closes successfully, the expiration of the agreement term, the listing period ends, the destruction or condemnation of the property, if the house burns down or is taken by eminent domain, or the death, incapacitation, or bankruptcy of either the principal or the broker, not usually the salesperson, but the responsible broker. Condemnation stemming from eminent domain is indeed an example of termination by operation of law. The government taking the property makes the private agency agreement to sell it impossible. Termination by acts of the parties, on the other hand, involves actions taken by the people involved: mutual agreement to terminate, revocation, when the principal unilaterally fires the agent, though they might still owe damages if it breaches the contract, renunciation, when the agent unilaterally quits, again with potential liability, or a significant breach of the agreement or fiduciary duties by either party. For instance, if Peter just doesn't trust his broker anymore, he might revoke the listing agreement.
This clarifies so much about the human element, the relationships and responsibilities in real estate, truly demystifying who works for whom and what's expected. But of course, a property isn't just about who owns it and who represents the parties. It's also critically about its financial value and how these big transactions are actually funded.
the dollars and cents property valuation, and the lending process.
All right, let's talk money. Because at the end of the day, these are huge financial transactions. Before a property can realistically change hands, everyone involved, buyer, seller, lender, needs to have a solid idea of what it's truly worth. And then for most buyers, the million-dollar question, sometimes literally, is how do they actually secure the funds to buy it? What are the main tools for valuation, and how does that whole lending process work from start to finish? It seems daunting.
It can seem daunting, but breaking it down helps. Valuing a property accurately is absolutely crucial, as it underpins every financial decision that follows. There are different methods used, each serving a distinct purpose and offering varying levels of formality and reliability. The most official and legally recognized method is an appraisal. This is a formal, unbiased valuation of a property's market value conducted by an impartial, state-licensed or certified appraiser. It's considered an opinion of value, but it's an opinion supported by rigorous analysis of market data, property condition, and relevant factors specific to that property as of a precise date. Lenders rely heavily on appraisals to ensure the property is adequate collateral for the loan.
So the bank requires this to protect their investment.
Exactly. Appraisers must be licensed in California and are rigorously regulated by the California Bureau of Real Estate Appraisers, DREA. They must follow the Uniform Standards of Professional Appraisal Practice, USPAP. USPAP is a critical ethical and performance code. Notably, it states that it is unethical for an appraiser to accept compensation that is contingent upon reaching a certain value. Their fee must be independent of the outcome to ensure impartiality.
So they can't be paid more if they appraise it higher. Makes sense for objectivity.
Correct. And also important to remember, in California, home inspectors, while vital for assessing condition, are specifically prohibited from giving an opinion of value. That's the appraiser's job. So if a lender needs that expert, objective opinion of market value, they order an appraisal.
Okay, appraisal is the gold standard for valuation, especially for lenders. What else is used? Agents talk about CMAs all the time.
Right. While appraisals are formal and required by lenders, real estate agents use a very valuable tool called a comparative market analysis, CMA. This is essentially a report agents prepare, usually for sellers, to suggest a well-researched listing price range. It works by comparing the subject property, the house being listed, to similar properties, comparables or comps in the same area that have recently sold, are currently pending sale, or are even actively listed.
Looking at what the competition is doing.
Exactly. Creating a good CMA is a crucial skill for listing agents. It helps sellers understand where their home fits in the current market dynamics. It's usually done for free as part of the listing service, unlike an appraisal, which involves a fee. A key takeaway, though, and a point of common confusion, a CMA is not an appraisal. It's typically less detailed, less formal, and less reliable for official lending purposes. However, both appraisals and CMAs heavily rely on the sales comparison approach, analyzing similar property sales.
So CMA helps set the asking price. Appraisal confirms the value for the loan.
That's a good way to put it. There's also a broker price opinion, BPO, sometimes called a broker's opinion of value, BOV. This is a broker's written opinion of a property's likely selling price. It's similar in concept to a CMA, but often shorter, less formal, and might be used in specific situations like commercial real estate, or very commonly by lenders during foreclosure processes, or for home equity lines of credit, mainly because it's cheaper and quicker to obtain than a full appraisal. It's an estimate, but done by a licensed broker.
Okay, appraisal, CMA, BPO. Different tools for different valuation needs. So once we have a handle on the property's value, how does someone actually secure the financing for such a large purchase? What does the lending process really entail, especially from the borrower's perspective trying to navigate it?
The loan origination process is definitely multi-step and rigorous. Lenders are careful. They want to ensure the borrower can repay the loan and that the property is sufficient collateral. It culminates, hopefully, in a borrower obtaining a mortgage loan. It really starts with approving the borrower. This often begins informally with pre-qualification. Here, a lender gives a very general estimate of how much a borrower might qualify for, usually based just on what the borrower tells them about their income and debts. It's quick, maybe over the phone, but not very reliable.
Just a rough ballpark.
Exactly. The next, more robust step is pre-approval. Here, the lender actually pulls the borrower's credit report, verifies income and assets to some extent, and reviews their overall financial profile more thoroughly. If things look good, they issue a pre-approval letter stating the borrower is likely qualified for a loan up to a certain amount. This pre-approval letter is huge for buyers. It offers significant assurance to sellers that the buyer is serious and financially capable, making their purchase offer much stronger in a competitive market.
So pre-approval carries more weight than pre-qualification.
Much more weight. The real heavy lifting of borrower approval, however, happens during underwriting. After a purchase contract is signed and a formal loan application is submitted, the underwriter, working for the lender, conducts the final in-depth analysis. They scrutinize the borrower's creditworthiness and evaluate the property as collateral. Underwriters typically look at 5 key aspects of the applicant's financial profile, sometimes called the 5 C's of credit. 1. Capacity. Can the borrower actually afford the payments, based on income, job stability, etc.? 2. Capital. How much skin does the borrower have in the game? Down payments, savings, assets. 3. Collateral. Is the property itself valuable enough to secure the loan? That's where the appraisal comes in. 4. Character. Is the borrower likely to repay? Assessor of credit history and FICO scores. A higher FICO score generally indicates lower default risk. 5. Conditions. What are the loan terms, interest rate, loan type, and what are the broader economic conditions? They'll verify income, review credit reports in detail, look at assets like bank accounts, debts, car loans, student loans, credit cards, and calculate the borrower's net worth, which is simply assets minus debts.
Okay, they dig deep into your financial life.
They have to. Crucial tools in underwriting are qualifying ratios. These ratios aren't just arbitrary numbers. They are the lender's primary way to assess risk, specifically the risk that the borrower won't be able to make their payments. They want to ensure the applicant can comfortably handle the mortgage payment and their other debts. The first key ratio is the payment-to-income ratio, also called the housing expense ratio or the front-end ratio. This compares the estimated total monthly mortgage payment, which includes principal, interest, taxes, and insurance, often called PITI, to the borrower's gross pre-tax monthly income.
PATI compared to income, what's a typical limit?
For conventional loans, those not backed by the government, the PITI payment typically cannot exceed 28% of the borrower's gross monthly income. For FHA loans, insured by the Federal Housing Administration, the limit is slightly higher, usually around 31%. So for example, if someone earns $6,000 a month gross, using the 28% conventional ratio, their maximum allowable PITI payment would be about $1,680.926. Lenders use this as a first check on affordability.
Okay, that's the housing cost itself. What about other debts?
That brings us to the second key ratio, the debt-to-income ratio, DTI, also known as the total debt service to income ratio, or the back-end ratio. This one is more comprehensive and often more critical. It compares the borrower's total recurring monthly debt payments, including the proposed PITI mortgage payment, plus payments on things like car loans, student loans, credit card minimum payments, and other installment debts to their gross monthly income.
So PITI plus all other long-term debt payments.
Exactly. For manually underwritten conventional loans, this total DTI ratio is typically capped at 36% of gross monthly income. For FHA loans, the back-end DTI limit is generally 43%. Some automated underwriting systems might allow slightly higher ratios in certain circumstances. This DTI ratio looks at your entire financial picture. It's designed to ensure you're not over-leveraged across the board and can comfortably manage all your financial obligations, not just the mortgage. It's essentially a stress test.
2,836 for conventional, 3,143 for FHA. Those ratios seem really important for qualification.
They are fundamental gatekeepers in the underwriting process. Now, beyond scrutinizing the borrower, the lender also focuses intensely on approving the property. Remember, the property is the collateral securing the loan. The lender needs assurance that if the borrower defaults, the property's value is sufficient to cover the outstanding loan balance. This involves extensive due diligence, including ordering that title search we discussed earlier to ensure clear ownership free of problematic liens, and, crucially, the appraisal to confirm the market value. The loan-to-value ratio, LTV, is a key metric here. It's calculated simply as the loan amount divided by the property value, or purchase price, whichever is lower. A higher LTV, say 95%, meaning only enough 5% down payment, is considered riskier for the lender than, say, an 80% LTV, a 20% down payment.
Higher LTV means less equity, more risk for the lender.
Precisely. That's why loans with an LTV above 80% typically require the borrower to pay private mortgage insurance, PMI, on conventional loans, which protects the lender in case of default. For commercial or investment properties, lenders often use a different metric called the debt service coverage ratio, DSCR. This is calculated as the property's net operating income, NOI, divided by its total debt service, annual principal and interest payments. Lenders want to see a DSCR above 1.0, ideally 1.2 or higher, ensuring the property itself generates enough cash flow to cover its mortgage payments.
Okay, so the property has to pass muster too. Once the borrower and the property are both approved, we get to the finish line, the closing. What are the key documents and financial aspects that a borrower absolutely needs to understand at this final stage? It can feel like a whirlwind of paper.
It really can be a whirlwind. The final stage is closing the loan, and transparency here is mandated by law to protect consumers. Two key documents stand out. First, the loan estimate, LE form. This is a standardized disclosure the lender must provide within 3 business days after receiving the borrower's complete loan application. It clearly highlights the key features, costs, and risks of the proposed loan, estimated interest rate, monthly payment, total closing costs. It's designed specifically so borrowers can easily shop around and compare loan offers from different lenders.
So you get this early on to compare apples to apples.
Exactly. Then, just before closing, comes the closing disclosure, CD form. This is the critical final document. It provides the final, detailed, itemized breakdown of all the services and fees associated with the transaction, loan costs, title fees, recording fees, prorations, everything. It reconciles the estimated costs from the loan estimate with the actual final figures. Crucially, under federal law, the Taylor-Respa Integrated Disclosure Rule, or TRADE, the borrower must receive the closing disclosure at least 3 business days before the scheduled closing day, the day they sign the final loan documents.
3 days to review before signing. That seems important.
It's a vital consumer protection measure. It gives borrowers time to review the final numbers carefully, compare them to the loan estimate, ask questions, understand exactly what they're paying, and prevent being rushed into signing documents with last-minute surprises or changes. If this 3-day deadline is missed, or if there are significant changes to the loan terms, like the APR changing beyond a certain tolerance, the closing must be legally delayed until the borrower has had the required 3-day review period with the corrected disclosure.
So that 3-day rule is firm.
Very firm. Both the loan estimate and closing disclosure forms were designed to bring simplification and transparency to what was historically a very confusing process. Both forms also contain a clear calculating cash to close section. This summarizes exactly how much money the buyer needs to bring to the closing table, accounting for the loan amount, down payment, closing costs, any credits like earnest money already paid, and prorations.
Cash to close. The bottom line number. Okay, what about things like points? You hear about paying points.
Right. Discount points are an interesting aspect of loan costs. 1 point equals 1% of the loan principal amount. Borrowers can choose to pay these points up front, at closing, to essentially buy down or lower their interest rate over the entire life of the loan. Paying points increases your upfront closing costs, but it can result in a lower monthly payment and potentially save you a significant amount in total interest over, say, a 30-year mortgage.
So you pay more now to pay less later. How do you know if it's worth it?
You need to calculate the break-even point. You do this by dividing the total cost of the discount points by the amount you save on your monthly payment due to the lower rate. For example, let's say paying 1 point, $3,000 on a $300,000 loan, lowers your monthly payment by $50. The break-even point is 60 months. $3,000, $50, $60. If you plan to stay in the home longer than 60 months, 5 years, paying the point could save you money in the long run. If you plan to move sooner, it might not be worth it.
Okay, break-even calculation, that's practical. Is there an opposite to points?
Yes, there are lender credits. These work in reverse. You agree to accept a slightly higher interest rate on your loan, and in return, the lender gives you a credit, essentially cash back, that can be used to offset some or all of your closing costs. This can be appealing for borrowers who are short on cash for closing, but it means a higher monthly payment and paying more interest over the life of the loan. It's a trade-off.
Points lower the rate but cost upfront. Credits raise the rate but lower upfront costs. Choice is based on your situation.
Exactly. And one final practical insight into how these loans work, particularly fixed-rate, amortized loans, which are very common. People sometimes get confused about principal versus interest. In a fixed-rate, fully amortized loan, the total monthly payment of principal and interest remains the same for the entire loan term. However, the allocation within that payment changes dramatically over time.
How so?
Your payments are always credited first to the interest due for that month. In the early years of the loan, when the principal balance is high, most of your fixed payment goes towards interest, and only a small portion goes to reducing the principal. But as you gradually pay down the principal balance each month, the amount of interest due decreases. Since the total payment is fixed, a larger and larger portion of that payment goes towards principal reduction later in the loan term.
So you build equity faster towards the end.
much faster. For example, on a $300,000 loan at 5% for 30 years, the principal and interest payment is around $6,610. In the very first month, $1,250 of that goes to interest, $300,000 on year 5, and only about $360 goes to principal. By year 20, maybe only a few $100s goes to interest, and the rest, over $1,000, goes to principal reduction each month. Understanding this amortization schedule helps you see how equity builds over time.
Wow, that really does break down the financial journey, doesn't it? From the initial appraisal and getting pre-approved through underwriting with those crucial ratios, right down to the final numbers on the closing disclosure and understanding points and amortization. It's clear how interconnected and detailed it all is. But once the money is sorted, the loan is approved, how does the actual legal transfer of ownership happen? What's the significance of that final handover moment?
The handover deeds, title, and escrow.
Okay, we've covered what you own, those estates and interests, what might burden it, encumbrances, liens, who helps make the deal happen, agency, and how you get the money, valuation and lending. Now, for the big moment, right, the grand finale of the transaction, how does ownership officially change hands? What's the subtle but crucial difference between a deed and a title? People use those interchangeably sometimes. And what exactly happens in that critical, almost mysterious process called escrow, which seems so central to transactions here in California?
This is indeed where the legal transfer becomes concrete the moment everything culminates, and it's a phase filled with legal precision and important details. Let's start with title versus deed, because you're right, it's a common point of confusion. Title refers to the actual legal ownership of real property. It encompasses that bundle of rights we discussed way back at the beginning, the rights to possess, use, enjoy, exclude others, and dispose of the property. Critically, title is not a physical document. It's a concept, a legal status, your rightful claim to ownership.
So title is the concept of ownership.
Exactly. A deed, on the other hand, is the tangible legal document that formally transfers or conveys real estate title from one party, the grantor, usually the seller, to another party, the grantee, usually the buyer. Deeds are the instruments used to make the transfer official. They create a public record showing that the property has changed hands. So, for instance, if someone leaves property in their will, the will directs a transfer, but an executor's deed would likely be the actual document executed by the estate to legally transfer the title to the heir.
Okay, title is the ownership right, deed is the transfer document. Got it.
Perfect. Now, the transfer of property itself is legally termed alienation. Fancy word for transfer.
Alienation. Okay.
Yeah. This can occur in two primary ways. Voluntary alienation is the most common. It happens willingly, typically by sale or gift. This is what we see in most real estate transactions. Examples include a private grant, when selling property between individuals using a deed, dedication, when gifting land to a government for public use, like donating land for a park, or devise, when transferring property through a valid will upon the owner's death. If Chanel sells her home to Erica using a grant deed, that's a classic example of voluntary alienation.
Willing transfer. Makes sense. What's the opposite?
Involuntary alienation. As the name suggests, this happens through operation of law, without the owner's consent, or sometimes even their action. There are several ways this can occur. Eminent domain, where the government takes private land for a public purpose, like building a highway, upon payment of just compensation. We also called this condemnation earlier. Foreclosure, where a lender seizes and sells property because the borrower defaulted on their loan payments. Lawsuits can also lead to it, like a quiet title suit, where a court resolves an ownership dispute and might award title to one party over another, or a partition suit to divide co-owned property. Adverse possession is that fascinating one we discussed, where someone can gain ownership by openly occupying and using land and paying taxes on it for 5 years in California against the true owner's rights.
So the original owner loses title involuntarily.
Correct. Escheat happens when a property owner dies intestate without a valid will and has no identifiable legal heirs. In that case, the property ownership reverts, or escheats, to the state of California. So if Quinn dies intestate and truly has no relatives, his property goes to the state through escheat, another form of involuntary alienation.
Yeah.
And lastly, forfeiture of title can occur if a condition in a deed is violated. Remember that fee simple subject to condition subsequent. If the condition is broken, the title might automatically revert to the previous owner or their heirs.
Wow, several ways to lose property without meaning to.
Indeed. Now, for a deed to actually be valid and effectively transfer title in California, it must meet several specific legal requirements. It must be in writing. It must clearly identify the grantor and the grantee. It needs an adequate legal description of the property being conveyed. It must contain words of conveyance language showing the intent to transfer title like grant and convey. And critically, it must be signed by the grantor or their authorized agent. Acknowledgement, having the signature notarized, is generally required for recording, but not strictly for validity between the parties.
Signed by the grantor is key. Does it need to be recorded?
That's a really important practical point. While recording a deed in the county public records is not technically required for it to be valid between the grantor and grantee themselves, it is absolutely essential for protecting the grantee against later claims. Recording provides constructive notice to the entire world, meaning everyone is legally considered to know about the transfer because it's in the public record. An unrecorded deed can potentially be invalidated by a later deed from the same grantor to a different grantee if that second grantee records their deed first and didn't know about the earlier unrecorded one.
So record immediately to protect yourself.
Absolutely. Prudent practice is always to record promptly. The proper execution of a deed truly involves not just signing, but also delivery by the grantor with the unequivocal intent to transfer title now and acceptance by the grantee, which is usually presumed if the transfer is beneficial.
Okay, validity versus recording. That's a key practical distinction. Now, you mentioned grant deeds are common in California. Are there different types of deeds, and what kind of promises or protection do they offer a new owner?
Excellent question. Because the type of deed used significantly impacts the level of protection the grantee receives against future title problems. There are several main types. A warranty deed offers the strongest and broadest guarantee of title. With a warranty deed, the grantor makes several specific promises, called covenants, about the title, essentially guaranteeing it against any defects, even those that arose before the grantor owned the property. Think of it as the gold standard of protection for the buyer.
What kind of promises?
Key covenants include the covenant of seisin, a promise that the grantor actually owns the property and has the right to convey it. The covenant of quiet enjoyment, a promise that the grantee's ownership won't be disturbed by someone else with a superior claim. And the covenant of warranty forever, a promise that the grantor will defend the grantee's title against claims and compensate them for losses if the title fails. This deed provides the greatest protection. However, they are less common in California compared to grant deeds.
Okay, warranty deed is top tier. What about the grant deed used here?
A grant deed, which is the most commonly used deed in California transactions, is less comprehensive. It protects the grantee only against defects or encumbrances that occurred while the grantor held title. It implies two main warranties by law. First, that the grantor hasn't already conveyed the same title to someone else, and second, that the property is free from any liens or encumbrances placed on it by the grantor, unless disclosed in the deed. It does not warrant against title issues that existed before the grantor acquired the property.
So protection only during the seller's ownership period.
Correct. Then there's a bargain and sale deed. This type implies the grantor holds title and possession but offers no express warranties against encumbrances. It provides minimal protection. It's worth noting these are generally not used in California.
Okay, skip that one for California. What about quitclaim deeds?
The quitclaim deed. This one conveys any interest, title, or right the grantor might have in the property at the time the deed is executed, but it makes absolutely no guarantees about ownership or whether the title is clear. It essentially says, whatever interest I may have, if any, I'm giving it to you, but I'm making zero promises about what that interest is or if it's valid or if the title is good. It offers the least protection to the grantee.
So why would anyone use a quitclaim deed?
They're often used to clear a cloud on the title. For example, in a divorce, one spouse might sign a quitclaim deed to transfer any potential interest in the family home to the other spouse.
Blah.
Or it might be used to correct a minor error in a previous deed, like a misspelled name, or release a potential uncertain claim. It's a way to remove doubt, not to guarantee ownership.
Got it. Clearing clouds, not conveying guaranteed title.
Precisely. Now, regarding conveyance after death, the process depends on whether the deceased owner left a valid will. If an owner dies intestate, meaning without a valid will, their property is distributed to their legal heirs according to California's laws of descent and distribution, overseen by a court-appointed administrator through the probate process. If an owner dies testate, meaning with a valid will, their property is distributed according to the instructions in the will. An executor, named in the will, or an administrator, if no executor is named or able to serve, oversees this distribution, also typically through probate court, paying debts and taxes first.
Probate seems likely either way, unless maybe a trust was used.
Often, yes, those simpler procedures might apply for small estates. Wills themselves can be formal, typically prepared by a lawyer, signed by the testator, the person making the will, and witnessed by at least two competent disinterested individuals, or holographic. A holographic will is one that is entirely handwritten, dated, and signed by the testator. Critically, it does not need witnesses in California. While legally valid if done correctly, holographic wills can sometimes face challenges regarding interpretation or proof of the testator's intent, if not perfectly clear.
Handwritten, dated, signed, no witnesses needed for holographic. Interesting.
It is, but formal wills are generally less prone to challenge.
So you've got the deed, the document transferring ownership, but what about ensuring the title, that concept of ownership, is actually clean and legally sound? How do you protect against hidden problems? And how does all this funnel into that critical yet often kind of opaque process of escrow? Escrow seems like the central hub for California transactions.
You're absolutely right. Ensuring a clean and secure title is paramount for both the buyer and their lender. What everyone wants and needs is marketable title. Marketable title is a title that is reasonably free from serious defects or doubts, free from the risk of litigation or legal exposure, and reasonably sellable or mortgageable to a prudent purchaser. It's what every buyer expects and what every lender requires before funding a loan.
Free from doubt, free from lawsuits. Makes sense. How do you prove you have it?
The best and standard way to show evidence of title and protect against unknown defects is through title insurance. This is a crucial protection mechanism in U.S. real estate. Title insurance is an insurance policy that protects homeowners, an optional policy but highly recommended, and lenders, a mandatory policy for virtually all loans, from financial losses arising from hidden title defects, unknown liens, undiscovered encumbrances, or even things like fraud or forgery in the property's history that weren't found during the initial title search.
So it protects against past problems popping up later.
Exactly. While it might seem like just another closing cost for an informed buyer, the owner's title insurance policy is one of your strongest defenses against unforeseen claims that could potentially challenge your ownership or wipe out your equity. It's not just a formality, it's crucial peace of mind against historical ghosts in your property's chain of title. Before issuing a policy, the title company performs an exhaustive search of public records related to the property. Based on this search, they issue a title commitment, or preliminary report, outlining the terms of the proposed policy and listing any exceptions specific known issues like existing easements or current property taxes that the policy will not cover.
So you know what's covered and what's not.
Correct. And recording, as we touched on, is the process of formally documenting any transfer, lien-in, or claim of interest in real property in the official public records, usually maintained at the county recorder's office. Recording provides that constructive notice we talked about, legally notifying the world of the transaction or claim. Anyone diligently searching the records could find it. This is distinct from actual notice, which is direct first-hand knowledge someone has, like being explicitly told about an easement. And in California, when property sells, there's typically a real estate documentary transfer tax assessed. The rate is generally 55 cents per $500 of the property's value or the consideration paid, though some charter cities might have additional local transfer taxes. This is usually paid by the seller.
Okay, title insurance protects, recording gives notice. Now, escrow, how does that work?
Finally, we arrive at escrow and settlement. This is the crucial, neutral third-party process that facilitates the closing of most real estate transactions in California. The escrow holder, or escrow agent, acts as a neutral stakeholder. They hold all the funds, like the buyer's deposit and loan funds, and important documents, like the deed and loan documents, in trust until all the specified conditions of the purchase agreement and the lender's requirements have been met.
So they don't release anything until everything is done.
Exactly. In California, for escrow to be valid, there must be a binding contract between the buyer and seller and the conditional delivery of transfer documents and funds to the neutral third party, the escrow holder. This ensures that neither party can unilaterally back out or gain an unfair advantage before all agreed-upon conditions, like inspections, loan funding, title clearance, are satisfied.
Who can be an escrow holder?
Escrow holders can be independent escrow companies licensed by the Department of Financial Protection and Innovation, DOPI, or they can be controlled escrow companies, which are often divisions of larger entities like banks, savings and loans, title insurance companies, or attorneys acting in that capacity. Under very specific limited circumstances, real estate brokers themselves can act as escrow holders, but only if they are also the listing or selling broker in that same transaction and are not advertising solely for escrow services. It's rare and highly regulated due to potential conflicts of interest.
So usually a dedicated escrow company or title company handles it.
That's most common. The escrow agent has a limited agency relationship with both the buyer and seller. Before closing, they are effectively a neutral, dual agent, obligated only to follow the mutual instructions of the parties impartially. After closing, they become an individual agent for each party for specific post-closing duties, like recording the deed or dispersing funds. The roadmap for the escrow holder is the escrow instructions. These are the detailed written documents signed by both the buyer and seller, given to the escrow holder, outlining precisely how the parties want the transaction carried out, conditions to be met, documents to be used, funds to be allocated, prorations calculated, etc.
So the instructions have to be clear and agreed upon.
Absolutely. If there is a conflict between the instructions given by the buyer and seller, or if a dispute arises that the escrow holder cannot resolve, they can initiate an interpleader action. This means they turn the documents and funds over to a court and ask the judge to decide how to proceed, protecting the escrow holder from liability for making the wrong decision.
A way out if the parties disagree. Okay, let's talk closing costs. What are the typical expenses buyers and sellers face?
Closing costs are all the various fees and expenses incurred during the transaction beyond the purchase price itself. These are typically allocated between the buyer and seller according to the purchase agreement or local custom, and they are itemized on that final closing disclosure. Some are one-time charges, others are recurring. Title fees and inspection fees are good examples of non-recurring closing costs you pay once for that specific transaction.
What does the buyer usually pay?
Buyer's typical costs often include the appraisal fee required by the lender, loan origination fees charged by the lender, discount points if they choose to pay them, recording fees for the deed and mortgage deed of trust, around $75 per document is common in CA, the first year's homeowner's insurance premium, paid up front, the lender's title insurance policy premium, customarily buyer paid in many parts of CA, and reserves deposited into an escrow impound account for future property tax and insurance payments.
Okay, quite a list for the buyer. What about the seller?
Seller's typical costs usually include the real estate broker's commission, often the largest single closing cost, the documentary transfer tax, 75 cents per $500 of value in CA, plus any local taxes, costs associated with satisfying existing LinkedIns, like paying off their outstanding mortgage balance, and the owner's title insurance policy premium, customarily seller paid in many parts of CA. Local customs can vary significantly on who pays for title and escrow fees, though.
Commissions and paying off their old loan are big ones for the seller.
Definitely. A key aspect of allocating costs fairly at closing is proration. Many expenses associated with homeownership are recurring, like property taxes, HOA fees, maybe rent if it's an income property. These need to be prorated, meaning they are divided proportionally between the buyer and seller based on the actual number of days each party owns the property during the billing period, in between the tax year or the month.
So you only pay for the days you actually own it.
Exactly. For calculation purposes in California real estate, a banker's year of 360 days, 12 months of 30 days each, is often used to simplify these proration calculations, unless the agreement specifies otherwise. For example, let's say property taxes are $5,400 per year, paid in advance by the seller. If the closing occurs with 2 months and 10 days remaining in that tax period that the buyer will now occupy the home, we need to credit the seller for the portion they prepaid but won't use, using the 360-day year. The monthly tax cost is $450, $5,400 $12, and the daily cost is $15, $450 $30. So the buyer would owe the seller a credit for 2 months, $900, plus 10 days, $150, totaling a $1,050 proration credit to the seller, debit to the buyer at closing.
Okay, math based on a 30-day month, usually.
Usually. Similarly, if a seller paid $1,536 in annual HOA fees up front, and the buyer takes possession with 5 full months left in that prepaid period, the monthly cost is $128, $1,536 for 12. The buyer would then owe the seller a credit of $640, 128 5 months at closing. And importantly, any earnest money the buyer deposited when making the offer is always shown as a credit to the buyer on the closing disclosure, as it's money they've already contributed towards the purchase price and closing costs.
So earnest money reduces the cash needed at closing.
Correct. The net to seller is the final calculation showing the actual amount of money the seller walks away with after all their credits, like the purchase price and prorations owed to them, have been added up, and all their debits, like loan payoff, commissions, closing costs, prorations they owe, have been subtracted. The entire process of meticulously verifying all these debits and credits on the closing disclosure for both buyer and seller to ensure the numbers add up correctly is known as reconciliation. Escrow handles this final accounting.
That was an incredible amount of detail on those final pivotal steps: deed, title, recording, insurance, escrow, costs, prorations, reconciliation. It truly shows how many moving parts there are, how interconnected they all are, and why understanding each piece is so crucial, whether you're buying, selling, or working in the industry. It's definitely not simple.
Outro. Wow. What an absolute deep dive that was. We have really navigated the landscape today. We started with the foundational concepts of property ownership, possessory, non-possessory interests, freehold, leasehold, life estates, how property can be held in severalty or co-owned.
Tenancy in common, joint tenancy, community property, lots of key distinctions there.
Exactly. Then we moved on to the critical encumbrances and liens that can affect a property's title and value: easements, deed restrictions, mechanics liens, tax liens, and that all-important lien priority.
Especially that property tax priority, that always tricks people up. Right. From there, we explored the intricate world of agency relationships, client versus customer, those OLDCAR fiduciary duties, special versus general agency, and the complexities and rules around dual agency and subagency.
Getting those relationships right is fundamental to ethical practice.
Absolutely. Then we demystified the often opaque process of property valuation appraisals, CMAs, BPOs, and the loan acquisition process, breaking down underwriting, those qualifying ratios, LTV, and the key disclosures like the loan estimate and closing disclosure.
Understanding the numbers is key for buyers and sellers.
For sure. And finally, we walk through the critical legal steps of the handover: the deed transfer, ensuring marketable title with title insurance, the importance of recording, and the intricate protective process of escrow, including all those closing costs and prorations.
It's abundantly clear, isn't it, that real estate is far more than just bricks and mortar or plots of land. It's a complex, dynamic ecosystem. It's woven with legal principles, sophisticated financial mechanisms, and crucial human relationships, all governed by specific, often highly detailed regulations. Understanding these layers truly empowers you, whether you're considering a career in real estate, maybe embarking on the exciting journey of buying your first home, or simply aiming to be a more informed citizen who understands the backbone of property rights in our society.
Absolutely. The sheer amount of interconnected detail, the way each piece, ownership, encumbrances, agency, finance, closing, fits into the larger puzzle, is really what makes this field so endlessly fascinating, I think. And as you continue your journey, whether it's towards successfully passing an exam, using this as a sort of study guide for those tricky parts, or just building your general knowledge, remember this: the true value of being well-informed isn't just knowing the definitions, it's understanding how all these concepts interact, what the practical implications are, and what that truly means for you and your future decisions.
Indeed. And this entire deep dive, particularly focusing on some of those areas that are commonly challenging or misunderstood, raises an important final question for you, the listener, to consider. In a world of increasing information complexity and evolving property landscapes, how will your deeper understanding of these California real estate fundamentals, the principles we've unpacked today, change the way you approach your next big financial or personal decision related to property? Will it make you perhaps more confident in negotiations, more discerning when reading contracts, maybe more aware of potential pitfalls, or simply a more engaged participant in transactions or even community planning? How will this knowledge empower you?
That is a truly thought-provoking question to chew on. How does knowing this change your approach? Excellent. Thank you for joining us on this deep dive into California real estate principles. Stay curious, stay informed, and we'll catch you on the next one.